Good afternoon, everyone, and welcome to the webinar, Trial Strategies for the Prosecution of Sexual Abuse and Confinement. My name is Charlene Whitman. I'm an Associate Attorney Advisor here at AEquitas, the Prosecutors' Resource on Violence Against Women, and I'll be moderating today's webinar. This presentation is designed to provide prosecutors and allied criminal justice professionals with information about challenges and strategies related to trying cases of sexual abuse and confinement. AEquitas already has presented two pre-related webinars entitled The Prosecution of Sexual Abuse and Confinement and Pretrial Motions and Mitigating Evidence in the Prosecution of Sexual Abuse and Confinement. Those webinars have been archived and can be accessed at www.equitasresource.org/training. Later this summer, on July 16th, AEquitas will present one additional prosecution-related webinar on issues related to witness intimidation in cases of sexual abuse and confinement and the utilization of forfeiture by wrongdoing to prosecute cases. Before we begin the substantive portion of our program, I'm going to provide a brief overview of our Ilink webinar service. You can listen to this webinar either via computer or conference call, but I strongly recommend calling in, from a landline to our conference line, 605-475-4700, and that passcode is 1003755#. That number is also in the upper left-hand portion of your screen. If you are using a mobile phone, please do not use the speaker option, but listen with an earpiece if necessary. And if your call gets dropped, please call back into the conference line as soon as possible. All call-in participants have been muted for the duration of the webinar, and today's webinar will be recorded for later viewing. To connect to Internet audio, please click the Connect button on your start screen. And if you use the Internet audio option, please do not also call into the webinar with a conference line. Only do so if you experience technical difficulty with your Internet audio. If you have any technical issues, you can use the Ilink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen, above the presenter's photo and to the right of the conference call number. Please take a moment to locate that hand raise option. And if you can use that hand raise option to show me how many of you today are using Internet audio. Great, thank you so much. And if you experience any technical difficulties throughout the webinar, you can also contact Ilink directly at 1-800-799-4510. Again, that number is 1-800-799-4510. And you can answer questions throughout this webinar and pose questions for our presenter through the webinar using Ilink's feedback indicator, located at the left-hand side of your screen. You can use that feedback indicator to answer a sample question. Let me know how many of you today have attended an Ilink webinar before. If the answer is yes, click yes. If the answer is no, click the no in the feedback window. And I'll give folks just a few minutes to respond to that. Okay, great. Thanks so much for your responses. Our presenter may also pose open-ended questions to which you can respond via private chat to me, Charlie Whitman, and you can also use private chat to share comments or ask questions throughout the webinar, which we strongly encourage. I am the only one who can see those questions and comments, and I will share them anonymously with our presenter and the group. And I encourage you to ask questions throughout and at the end of the webinar. Public chat has been disabled for this webinar. Finally, you can enlarge the content screen if you minimize the chat window by clicking on the arrow box in the left-hand corner of the chat window. If you'd like to reopen the window, please click on that same box again. Today's webinar, Trial Strategies for the Prosecution of Sexual Abuse and Confinement, is hosted by AEquitas, the Prosecutors' Resource on Violence Against Women, and the National PreResource Center through funding from the U.S. Department of Justice, Office on Justice Programs, Bureau of Justice Assistance. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you after this presentation. The National PreResource Center was established through a cooperative agreement between the Bureau of Justice Assistance and the National Council on Crime and Delinquency. The mission of the PRC is to assist adult prisons and jails, juvenile facilities, lockups, community community corrections, and tribal facilities in their efforts to eliminate sexual abuse by increasing their capacity for prevention, detection, monitoring, responses to incidents, and services to victims and their families. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, and provide individual experts to jurisdictions and organizations, publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter will be AEquitas Attorney Advisor Christopher Mallios. Prior to joining AEquitas, Mr. Mallios served as the Philadelphia District Attorney's Office Family and Violence and Chief of the Philadelphia District Attorney's Office Family Violence and Sexual Assault Unit. He also served as an advisor for the Philadelphia Police Department Special Victims Unit and Internal Affairs Division, and he co-chaired the Law Enforcement Subcommittee of the Philadelphia Domestic Violence Task Force. Mr. Mallios is currently an adjunct professor at the University of Pennsylvania School of Social Policy and Practice and an affiliate of the Ortner Center on Family Violence. And now we're going to start the substantive portion of our webinar. I'm going to play an audio recording for you all now.
Hello, State Ombudsman Reporting Hotline. How may I help you?
Hi, I'm sorry. This is an emergency, okay?
Ma'am, can you state your name? How may I help you?
I didn't know what else to do. I want to report a crime.
Okay, can you give me your name, ma'am?
Well, like I said, this is an emergency because it happened to me a while ago, but I just...
Well, ma'am, can you spell your first and last name for me? I would like to take a report and help you out.
No, but listen, I just saw a counselor here, and I asked her how to report something that happened to me earlier, and she said she handed me a brochure with your number, so that's why I'm calling.
Okay, calm down, ma'am. Tell me your name first.
My name is Sherry Sullivan. I want to report a rape, a sexual assault that happened to me.
Ma'am, when did this happen?
It happened a while ago. I'm locked up.
Are you in jail right now? Where are you being incarcerated?
I'm at SDWCF, the South Rockland Women's Correctional Facility, and I was raped. I was raped like all the time by a corrections officer. I heard that he was transferred or something, but I'm afraid he's going to come back here and try me again. His name is Officer Anderson, Thomas Anderson.
Can you repeat that name? Ma'am, are you there? Can you repeat that name, please?
You know what? I can't do this.
At the end of this webinar today, participants will be better able to develop trial themes and strategies throughout their opening statement, case-in-chief, cross-examination, and closing arguments. Support and work with victims who recant or do not want to participate in the criminal justice process, and overcome challenges including jury bias and defenses. I'm now going to turn the presentation over to Chris Mallios. Chris, you might be on mute. We can't hear you.
Good afternoon, everyone. Sorry about that. Thank you for joining us today. We just heard the inception of the case of State versus Thomas Anderson. This is a webinar about developing offender-focused trial strategies based on an informed understanding of victims and victim behavior and a focus on victims who do not want to participate in the process or who recant. Throughout the webinar, we encourage you to submit any prosecution-related questions or comments or questions about PREA and the standards, the latter of which will be answered by Tara Graham, Senior Program Specialist at the PREA Resource Center. Charlie, I'm having trouble advancing the slides.
You should be able to do that now.
No, it's not working. Oh, there we go. Okay, so we're going to start out with the definition of sexual abuse, which is the language used in PREA. Sexual abuse refers to contact between the penis and the vulva or anus, contact between the mouth and penis, vulva or anus, penetration of the anal or genital opening, and any other intentional touching, either directly or through the clothing, of the genitalia, anus, groin, breast, inner thigh, or the buttocks of any person that is unrelated to official duties or where the staff member, contractor, or volunteer has the intent to abuse, arouse, or gratify sexual desire. And that's in the 28 CFR section of 115.6. Now we have the statement of Sherry Sullivan. I've been an inmate at the South Rockland Women's Correctional Facility since November 11, 2012. I got picked up for possession of cocaine, and I was waiting for a trial or something. I'm waiting to get released, maybe this summer. One of the supervising officers on my block was Thomas Anderson. At first, he didn't bother me, but then I started working in the laundry, and he would be transporting a few of us down there every day, Monday through Friday. After just a few days in the laundry, that's when it started. He started pulling me out into a room off the side and raping me. It was like a closet, but bigger. It had a table in there that looked like it was an old table from a doctor's office. Sometimes he did it twice a day. It was always the same thing, except a couple of times. He always used a condom, turned me over, and put me face down so I was bending over a table, and then put his penis in my vagina from behind. The first time he said something like, if you know what's good for you, what is good for you, and you want me to take care of you and protect you in here, you will do this, or something like that. Honestly, I was so scared I didn't say a word. I would cry a lot in the beginning. He just ignored it. Sometimes he would give me some food or stuff or cigarettes before or after. I never said a word to anyone. I really just thought that he could kill me in there, so I didn't say anything. I never told anyone. A few of the girls would give me dirty looks, not just in the laundry, but like in the cafeteria too. But no one said anything to me. I wasn't going to report this. I just couldn't keep it in anymore. I do not want to press charges. I just thought about him being transferred and that he's going to do this to someone else somewhere. And I just don't want what happened to me to happen to anyone else. So that's Sherry Sullivan's statement. We're going to ask you a question now. If this case came across your desk, assume that you were working as a prosecutor. Would you A, take it to a grand jury, B, request additional investigation, C, call the victim immediately, or D, other, do something else? Please use the feedback portion of your screen to answer the question. So some folks would request additional investigation. Others might reach out to the victim immediately, but quite a few of you did not answer this question, and that's fine. The term offender-focused prosecution really needs to be explained. You need to realize that offenders purposely, knowingly, and intentionally target victims who they believe they can successfully assault. And it's important as prosecutors to keep the focus on the actions, behaviors, characteristics, and the intent of the offender. In these cases, you have to also understand the context of the victim. And the context of the victim is going to be defined by, in part, the offender, who has an ability to influence the truth, the relationship with the victim, and other things. The context of the victim will be defined by the victim's culture. Are there barriers to disclosure, barriers to access to services and other things based on the victim's culture? The victim's self. Is the victim blaming herself or himself? Does the victim have a prior history of victimization, or are there prior experiences that also shape how they look at what happened to them? And the context of the victim is also defined by the audience, and the audience is the other people who may look at this case, and it includes us, it includes prosecutors. The circumstances that influence the victim's response to abuse, the way in which the victim processed the abuse itself, the victim's thoughts and reactions to the assault, the victim's decision to call the reporting hotline, and the victim's reluctance to talk to a detective. The victim's thoughts and decisions regarding what she said or didn't say to the detective about the assault, all of these things. We have to think about all of this in order to fully understand and assess what happened and reconcile that with how the victim described what happened and what feelings and decisions the victim will have about proceeding with the prosecution of the offender. You need to think about this in advance and during your prep with the victim, and constantly be thinking, doing your best to understand the victim's context as they're talking about these things. So let's assume now that Sherry Sullivan is transported to the prosecutor's office for a trial prep session. She says she doesn't want to talk about the rapes, and she just wants the prosecutor to talk to her about what will happen during the trial. The prosecutor spends about 45 minutes talking about the process. Sherry says she will talk to the prosecutor another time prior to the trial. The prosecutor repeatedly calls the prison and goes to the prison twice to try and see Sherry. She will not agree to see the prosecutor. The prosecutor also reaches out to the local rape crisis center, which has a memorandum of understanding to provide sexual abuse advocacy services to the inmates. And she asked the rape crisis center to have the advocate assigned to Sherry relay a message that the prosecutor is trying to contact Sherry just to support her before trial, and that the prosecutor will come out to talk to Sherry or arrange for Sherry to be transported to the prosecutor's office. The weekend before the trial, the prosecutor plans to go to the prison again to try to see Sherry, but she has a family emergency and cannot go. The prosecutor calls the assigned detective and asks her to call or drive out to see Sherry. The assigned tells you that Sherry refused to come meet with her.
We're going to play another audio clip for you here, and it's transcribed onto your PowerPoint presentation as well.
Hi, Ms. Williams. It's Sherry Sullivan from the Anderson case. I'm calling because I just want the whole thing dropped. I want the charges dropped. I just cannot do this. Please just tell me what I have to do to get the case dropped. I have to sign something or whatever.
That was a voicemail message that the victim left for the prosecutor the day before the trial is supposed to start. The prosecutor calls the prison and asks the PREA coordinator to relay a confidential message to Sherry. Hello, Sherry. I'd like to talk to you about your message. I'm here to support you, and I just want to talk to you to make sure you're okay. I am here to support you. I will see you tomorrow in court. Please call me back. And Sherry does not call the prosecutor back. What should the prosecutor do on Monday? A, tell the defense attorney that the victim does not want to testify. B, tell the victim she has to testify. C, proceed without the victim's testimony. Or D, none of the above. There are some different responses here. Most of the participants are identifying C as the correct answer, to try and proceed without the victim's testimony. I just want to go back to that slide. With A, is the prosecutor ethically obligated to do this? Does the prosecutor have an ethical obligation to tell the defense attorney that the victim does not want to go forward? That really focuses on whether this is exculpatory evidence. And in general, reluctance to testify does not necessarily translate to Brady information or exculpatory information that needs to be disclosed to the defense. No one picked B, tell the victim that she has to testify, and that probably reflects the reality that this could be difficult for a victim, forcing a victim into the criminal justice system that doesn't want to be, and that there could be repercussions for that. In terms of C, proceeding without the victim's testimony, the question then becomes, are you able to do this with what you currently know about the case? But at this point, it is looking like that may be the most likely way to go. On Monday morning, the victim comes to court and tells the prosecutor that the rape never happened. What should the prosecutor do? A, conduct a victim interview. B, drop the case. C, have a victim witness advocate speak to the victim. D, tell her to think about it and call back in a few days. Is the prosecutor obligated to disclose the recantation to the defense? This is the discovery rule. We're going to refer here, because this is a multi-jurisdictional webinar, we're going to refer to the ABA standards, which provide guidance to criminal justice professionals. A prosecutor should not intentionally fail to make timely disclosure to the defense at the earliest feasible opportunity of the existence of all evidence or information which tends to negate the guilt of the accused or mitigate the offense charged, or which would tend to reduce the punishment of the accused. So this is a little different than reluctance to testify. This is actually a recantation, and the ethical rules, according to this, do require the prosecution to disclose that. Under further reading of the standards, a prosecutor should not fail to make a reasonable, diligent effort to comply with a legally proper discovery request, and a prosecutor should not intentionally avoid the pursuit of evidence because he or she believes it will damage the prosecution's case or aid the accused. So why do victims in sexual assault cases and in sexual assault cases for incarcerated victims, why do these victims recant? For many victims, recanting is an attempt to stop the criminal case from moving forward and just stop cooperating with the investigation or prosecution. The recantation and the failure to participate in the process could be related to and or caused by a multitude of things, including intimidation by the offender, pressure from others, the victim being too nervous to testify or be in a courtroom with the offender. If you have a victim who is out of incarceration, or even in incarceration, if they're working in the prison, they may be concerned about missing time from work. There are lots of reasons why victims in both prison rape cases and non-prison rape cases, there are lots of reasons why victims don't want to cooperate with these prosecutions. And it's just important to realize that this is often the context from which a victim is coming and the context in which they're making decisions about whether to go forward in these cases. There are also victims also considering safety risks, cultural barriers, considering their life changing by going forward, and unintended consequences. And there's serious concerns for victims in deciding whether to cooperate with a criminal prosecution against their offender. These decisions are also serious concerns for the criminal justice system, as prosecutions are often dismissed when victims fail to appear for trial. It's not an easy decision. It's actually a fairly complex decision. And every victim has to go through a balancing test. On one hand, deciding whether to participate. On the other hand, factors that weigh in favor of not participating. And we need to appreciate that perpetrators master and exploit all of these factors and dynamics to circumvent the criminal justice system and community efforts. And if you look at this slide, you'll see that safety is listed on both sides, the decision not to participate and the decision to participate. And in some cases, victims may determine that it's safer for them not to participate in these cases. Beliefs about rape and the myths about rape that a victim and a potential fact finder may have impact how the victim responds to the rape, how the victim explains the rape, and how we, who are part of the criminal justice system, react to the crime. And that certainly includes how the case is prosecuted and presented at trial, and then how judges and jurors process the evidence. Myths impact charging. They can impact case evaluation. They can also impact medical examinations and the level of support, what happens at the trial, case dispositions. These things are all affected by myths and often misconceptions about rape. And although there has been considerable research and publications in professional and popular journals concerning rape, these myths continue to persist in common law reasoning. There are attitudes that come out sometimes in reported cases. There are attitudes sometimes of law enforcement officers or jurors, and sometimes prosecutors and judges that all affect how these cases are handled. Assume that the victim recants to the prosecutor and then admits that the recantation was a lie. This is a little bit of an ethical question, but can the prosecutor be called as a witness in the case by the defense? What argument would you make requesting that the subpoena be quashed, assuming that you're a prosecutor and you were subpoenaed by the defense? What's the response to make if you are trying to avoid that subpoena? Because remember, sometimes attorneys will try to subpoena prosecutors to delay the case or get them off of the case. Well, if you take a look at the model rules of professional conduct, and here we're looking at the model rules, which are pretty much the basis for the state rules for all 50 states and for the territories. The rule states that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. And the key here, we've highlighted the word necessary because that's really the argument. The question is the lawyer a possible witness or are they a necessary witness? If there's another way to accomplish what the defense is trying to do without doing that, then the lawyer may not be a necessary witness under Rule 3.7a. A trial can often be seen as a series of hurdles, and the hurdles are surmountable with the right information and good advocacy skills. Don't estimate the power of deep-seated beliefs. So how do we proceed? How do we get these cases moving forward? How do we get to the actual trial? We like to advocate a two-step charging process in these cases. And the first step is assuming that the victim's version is true 100%, do the allegations constitute the crime of rape or sexual assault or whatever the crime is under the criminal codes of your jurisdiction. The second step is, can you prove the victim's allegations? And what we see so often in sexual assault cases when they're reported to law enforcement, so often we hear that victims from jurisdictions all over the country report sexual violence and they're told there's nothing we can do. And frequently, those cases are not even investigated to see if the victim's allegations can be proven. Sometimes it's just an assumption that because it happened in custody or because it happened with a victim who was using alcohol or drugs, and yes, these things sometimes are available in prison. Sometimes victims are just told there's nothing that can be done. And the question is that true? In many cases, it's not true. In many cases, these cases can go forward. The key to these cases is corroboration. Consider what other evidence might be out there. Are there 911 tapes, or in the case of a rape while in confinement, were there calls to the reporting hotline? Was there a medical examination? Was there a sexual assault forensic examination? Whether it was a sexual assault specific examination or just a examination by the medical providers in the prison, that may provide evidence that will corroborate what the victim is saying. Rule 404B of the Rules of Evidence refers to other crimes, other bad acts or other crimes committed by the accused in this case. Are there other crimes, other types of things that might be admissible that would show has the perpetrator done it before? Sometimes you'll find these things in a criminal background check. Sometimes you'll find it in an employee personnel file or a human resources file. There may have been administrating proceedings against someone if they're an employee. Sometimes photographs can corroborate what the victim's saying. A photograph of the crime scene, clothing that perhaps has been collected, a sketch of the crime scene, any behaviors or appearance or demeanor of the parties. How did they act? How did their behavior change after the incident? Requests for to change cell, requests for that a victim makes to transfer while they're in prison. Perhaps they don't report the sexual assault right away, but if they request a transfer away from the offender, that can also help corroborate that something happened. If the victim visited the prison infirmary, you need to know that. If not, why not? Sexual assault does cause injuries. Are you asking your detectives to take photographs? Is the detective interviewing any other corrections staff whose statements would corroborate the defendant's schedule, their opportunity to supervise the victim, access to that closet? In this case, she said it happened in a closet. Did the detective interview other inmates, those who work in the laundry? Did the detective interview the victim's cellmate? What about the inmates who cleaned? Did anyone find used condoms? Remember, the victim's statement said that he used a condom. Where could that have been disposed of? This really comes down to applying the principles of good evidence-based prosecution, where investigators gather evidence and prosecutors evaluate evidence at every step so that you're ready, so that you've already determined whether you're able to prosecute the case without the victim's participation. Some factors to consider in going forward with an evidence prosecution is there corroboration? And can you admit to corroboration? Is there evidence of motive here? Motive. Frequently, the defense will try to attribute motives to victim, motives to lie. But also, you need to realize that victims suffer consequences once they make these disclosures. It's very difficult to make a disclosure of sexual violence by someone who is in custody. And when someone makes that disclosure, there may be intimidation, there may be unwanted transfers, there may be unwanted restrictions placed on their freedom while even in custody, and taking all of this into account. What was the timing of the disclosure? What was the level of detail? Is what the victim is saying plausible? All of these are things that need to be considered when making a decision whether to go forward with an evidence-based prosecution. Some evidence that you have in the case may be inadmissible based on Crawford versus Washington. This is the U.S. Supreme Court that deals with the admissibility of testimonial statements. And when you try to go forward with a 911 call or a call to a hotline, when you try to go forward with statements made to investigators based on victims who are not available to testify at trial, you're going to have to consider the applicability and effect of the Crawford case to all of those statements. When it comes to voir dire, think about what behaviors you would like to address in voir dire. What questions do you think you could ask the jurors that might reveal juror bias? As you can see from the graphic on this slide, we have an article that I wrote with one of my colleagues about how to educate juries in sexual assault cases and how to use voir dire to eliminate jury bias. We want to use voir dire to determine potential juror biases or belief in rape myths and misconceptions. If you have a delayed complaint and the victim was an inmate, what questions do you think you would want to ask to get to reveal these biases? If anyone has any suggestions, you can type these into the chat, and we'll take a look at them and we'll discuss them a little bit. Questions about bias in favor of corrections officers may be one thing that you're going to look at. Questions about bias in favor of law enforcement. Questions about biases against inmates or biases that would lead jurors not to believe inmates or not care about inmates or not care about what happens in confinement. These are all the type of attitudes that you want to try and detect if they exist on your jury pool, on your jury panel, because they are going to impact whether the jury decides this case based on the evidence and the law and the facts, or whether they apply some other attitudes and come back with a verdict that may amount to jury nullification. Think about your closing argument. why does the closing come first? We like to always say the closing comes first. You want to know what your closing is going to be because you're going to want to use a theme in the prosecution of this case. Who is this defendant? How did the victim select the victim? How did he carry out this crime? How did he injure her? This slide, by the way, refers to perpetrators as males and victims as females, and the statistics support that those are the largest number of cases. But it's also important to realize that there will be male victims. There could also be female perpetrators. But just for the purpose of asking these questions, why is she believed? Why is the victim to be believed? In other words, how can you assess her credibility so that you know she's telling the truth? These are some of the themes that you want to explain to the jury. And this really comes first, deciding what that theme is going to be in your closing argument, because before you even prepare your opening statement, you should prepare your closing argument. You have to figure out what you need to prove your case and what you believe your arguments will be, and then prepare for the trial, figuring out how you will extrapolate the evidence from your witnesses. So some of these themes that we sometimes talk about are a wolf in sheep's clothing, maybe a protector who turned out to be a victimizer. In other words, in the case of someone who was there to protect the people who were confined and they turned out to be a perpetrator. I also like to pose a question sometimes in my opening or closing. What motive could the victim possibly have for fabricating the allegations, especially in cases where the victim is out of custody? And you're going to see cases where the victim is not able to talk about what happened to them until they get out of custody, until they're away from the perpetrator and they feel safe. You know, they may have determined that non-reporting is part of their safety plan until they get out of custody. Opening statement. The opening must be presented in direct contemplation of tying it to the closing. What he did, how he did it, what she will testify to, why what he did is unacceptable. If the jurisdiction has law that directly covers the relationship and it's per se liability, then talk about that and explain that in the very beginning. The perpetrator had a duty to protect the victim, and instead he perverted it. So think about this. Think about talking about the victim's behavior. How did the victim act after the assault? How did the victim act during the assault? How can you address some of these behaviors without putting the focus on the victim? And this is so important because the defense frequently will try to put the focus on the victim to take the focus away from the offender. And it's important that the prosecution keep the focus on the offender every step of the way while explaining the victim and the victim's response to the sexual violence in a way that's truthful and in a way that makes sense. When you think about the witness order, you're going to have a lot of potential witnesses in these cases, frequently not eyewitnesses to the crime itself, but victims to some of the facts surrounding the crime. The victim is a potential witness. Corrections officers assigned to her block. A corrections official who can explain the victim's or the defendant's schedule. A corrections official who can explain a map of the facility and the defendant's access to the victim. Think about the statement that we have from the victim in this case where there was a closet off to the side of the laundry room. Think about expert testimony on common victim behaviors or medical testimony. Is there a prompt complaint witness? In other words, who is the first person that the victim told about the sexual assault? Is the victim's statement to that witness admissible as an excited utterance? Are law enforcement officers, who the detective or the first responder or whoever processed the crime scene or investigated this case, are they all potential witnesses? They are, and they usually help to paint a complete picture for the victim. But don't assume when you're trying a case like this that the order of witnesses should necessarily be chronological order. Frequently, the most impactful way to present the evidence is by starting and finishing with impactful testimony. Think about not the chronological order of the case, but the strength of the witnesses and what they add to the case. There's a comment from a participant that said a female victim of an officer is in a somewhat sympathetic situation. We had a case with a victim of forced masturbation who was himself a sex offender, awaiting trial for sexually assaulting his 3-year-old granddaughter. the question is, can you comment on those kinds of tough situations where the victim is not sympathetic? I think that's an excellent question, and I think that these types of cases tend to lend themselves to victims who may be considered unsympathetic or perhaps in the eyes of the jury unlikable. And I think that a smart defense attorney is going to try and take advantage of that lack of sympathy and that unlikability of the victim to help the perpetrator escape criminal liability. This, again, starts in the very beginning of the case. It starts in voir dire, talking about how the law protects everyone and how the perpetrator, under the law, had a duty to protect the victim. You talk about it in your opening statement. You talk about it when you're doing direct examination of the perpetrator, and hammer it in closing, and talk about the law, and hold the jurors to the oath that they took in the beginning of the case to follow the law and apply the law to the facts and not superimpose judgments about the victim or bias for or against the victim or for or against the accused. Because if they follow the law, and if this is clearly a criminal act, which according to the question, forced masturbation by a corrections officer for someone who was incarcerated for a sex crime against a child, that is a crime under the law. And explaining that whatever happens to the victim in this case for the crimes that they were accused of, that's separate. And that needs to be dealt with in a completely separate proceeding. But what we're here for is what this offender did, what this offender did to this inmate, and how this offender used their position of power and control over this inmate to commit a crime of sexual violence. And talking about it in those terms, not shying away from any of the unfavorable facts. And by the way, it may not even be admissible what the victim is incarcerated for, unless there's something about the facts of the case that make it admissible. It may be completely proper to make a motion in limine to exclude the charges that the victim is incarcerated for. So it may be relevant, it may be admissible, but if it's not relevant and it's not admissible, then that shouldn't come in. And if it does come in, then it may be appropriate for that to come in with a limiting instruction. Perhaps tell the jury what the charges are, but not what the underlying facts of the case are. And tell the jury that although that comes in because it's somehow relevant to the case, that it does not reflect, it can only be used for the limited purpose of looking at how it's relevant to the facts of the case and not to hold the perpetrator less responsible or less culpable for what happened. For direct examination, the question is, should prosecutors address victim behaviors through their direct examination of the victim? And what are the pros and cons of asking victims to explain their behaviors? Some of these questions that prosecutors have to ask themselves are, is the victim able to explain what they did and why they did it? If they did not report right away, if they didn't tell anyone, or if they did tell someone but asked them not to report it to the authorities, why is that so? There are lots of reasons why victims act in certain ways. And if you have a victim who's able to talk about these things in a way that makes sense, this is a great opportunity to let the victim talk about what life is like in confinement and what they believe the consequences of going forward to be if they did that. There may be opportunities to have an expert witness testify about common victim behaviors, but experts are not always necessary and they're not always effective. The behavior might not even be the proper subject of expert testimony. And when you're considering experts, remember that all experts are not created equal. So it may be questioning of the victim that is the best way to explain victim behaviors that may seem counterintuitive to the members of the jury. These victim behaviors, which are also often going to be exploited by defense attorneys, can be addressed in voir dire. They can be addressed, as I said, by your questioning of the victim. They can be addressed through argument. They can be addressed by calling the expert to an expert in victim behaviors, or they can be addressed through some combination of all of these things, depending on the facts of the case and depending on the legal strategy and the legal tactics that the prosecution decides to pursue. So it's very important that these behaviors, which sometimes just really get in the way of justice in these cases because of myths and misconceptions about how victims act, it's just very important that they be addressed every step of the way. We know that the need to elicit facts that will directly tie into the crime's elements, but that will also explain the issues that we know our fact finder will have trouble with. We need to humanize Sherry, make her anyone we could know, so that her behavior makes sense to them, so that she can focus on the offender. So during direct examination, we need to bring out the elements and set the stage for eliciting information about her thoughts and behaviors that we can explain through our expert on victim behaviors, if we're going to call one, and then we can analogize during our closing argument. This point about humanizing Sherry is just so important. Now, we've talked a lot about victim behaviors. I've mentioned this a lot. What are some of the behaviors that jurors often don't understand or judge them to be counterintuitive? Well, a victim who fights back with earnest resistance. In other words, they don't scream, they don't yell, they're not shouting no, they're not fighting back violently, but they're almost like shutting down, and they make a decision for whatever reasons in however short period of time and fast period of time to not fight back with violent resistance, but fight back with passive, calm, earnest resistance. Sometimes jurors just don't understand this, and they think that that any rape victim should fight back with violent resistance. I can tell you in my experience, the cases in which the victims were hurt the most severely were often the cases in which victims fought back with violent resistance. Sometimes victims don't report everything at the same time. We call this delayed or piecemeal reporting, where they either don't tell what happened or they only tell parts of what happened. Sometimes you have victims who will have continued contact with the offender or even engage in subsequent sexual activity with the offender. These are all common behaviors for sexual assault victims that jurors often don't understand. If you, the prosecutor, know that these reactions are going to be judged by laypersons to be counterintuitive, and your victim reacted in one or more of these ways, you, through the testimony of your witnesses and in your closing argument, you must explain these behaviors. You must explain how and why the victim acted, and you must analogize these reactions to put them in context as a normal or regular reaction to rape. In other words, it seems counterintuitive, but when you think about it and you think about how we and most people we know respond differently to trauma, the victim's reaction makes perfect sense. For example, for earnest resistance, the explanation might be fear, frozen fright, or terror. Maybe a disbelief that it was happening. Maybe a belief that it would be worse or that the victim would be hurt worse. You may have a victim who, for cultural reasons, has been socialized to passivity. For delayed or piecemeal reporting, maybe the victim was not sure it was rape at all. Or maybe they're just afraid or they don't believe that it will do any good if they report. Sometimes the anger comes later, and sometimes from another party, like, for example, a parent who encourages the reporting after they hear about it. Sometimes you can have indirect or encouraged disclosure by other people. You may have victims who, because of culture or socialization to systems, decide not to report and then change their minds. And you just may have victims who are thinking about all of the potential consequences of going forward and going public with a report. This is going to be a significant issue in our case because we have, in the case with Sherry, because the victim did not report until she was out of custody. As far as continued contact with the offender, spend some time talking to the victim about continued contact that she may have had with him that was not related to mandatory work or other prison activity, or contact that may have been construed by others as voluntary. Again, in most states, any sexual contact between the victim and a defendant who works there is per se prohibited. But it's important to review the information because the defendant may have a twist on it. In other words, to assert a defense that this is a woman scorned, or that you might claim that they were friends, or that she wanted to be more than friends, or he might admit that they had an emotional connection but claim there was nothing more. And and that he resisted her advances or that she's fabricating. There are a lot of defenses that the defense can try to raise in these cases. And just keep in mind, jury nullification avoidance. In other words, jurors not even wanting to deal with these issues and just finding it easy to come back with an acquittal than to hold someone accountable for this. Possible explanations for continued contact, and some of them are the same reasons we've already discussed: shock or disbelief, a victim rushing to normalize their lives as much as they could, a prior relationship to the offender, a prior history of assault or abuse for the victim. You may have a victim who feels attachment and love for the perpetrator. They probably would not apply in the case that we're dealing with. And finally, subsequent sexual activity. If this is relevant in your case, you never know in a case of sexual assault in confinement. So you need to ask. You need to find out, has there been subsequent sexual activity? Did the victim continue to have a relationship, or did the abuse continue after the victim got out of custody? You may have it, and you're not going to know about it unless you ask. Some of the victim responses that are common in these cases, are self-blame. We already discussed this in the context in slide 12, but the identity of the assailant also impacts the victim's behavior, whether he's a stranger, if it was a brief encounter, if it was an acquaintance, or in the case that we're dealing with, someone who was trusted and a person of authority. All of this different type of blaming that all sexual assault victims sometimes do, you're also going to have for cases in confinement. So when we think about trauma and the trauma of sexual violence, think about what causes trauma. That's the first column. Extreme fear or terror, betrayal, blitz or surprise assaults, blame and shame, disastrous disclosures or reports, and a lack of support. In column 2, we're listing the effects of some of the effects of long-term traumatic stress, some of the behaviors that victims sometimes show after they are victims of sexual violence. A lot of anxiety and vigilance, or sometimes hypervigilance to protect themselves and keep themselves safe. Sometimes anger, resentment, and conflict, uncertainty about the future. Sometimes victims of traumatic stress will have prolonged mourning of losses. In other words, they lose a loved one, or they have some loss in their life, and instead of a normal period of mourning, it can go on for months and months or even years. These are some of the symptoms of long-term traumatic stress. Diminished problem solving. Sometimes victims will isolate themselves. Health problems can develop. You can have physical and mental exhaustion. And in some cases, victims will have a changed worldview. Their whole life will be different. Their whole outlook on their lives will be different after these types of crimes. The abuse itself, coupled with the victim's own judgment of her behavior, coupled with other people's responses to or lack of appropriate responses, can cause trauma. If you think about traumatic stress, depression and fear can lead to phobias and coping mechanisms. In some extreme cases, you may even have a post-traumatic stress disorder. In other cases, you may just have some of the symptoms of long-term traumatic stress. Experiencing an extremely traumatic event accompanied by symptoms of increased fear and avoidance of stimuli associated with the trauma are some of the is really the heart of the definition of post-traumatic stress disorder. When you're looking at deciding whether to call an expert witness or calling expert testimony on victim behavior, realize that the purpose of that is to provide jurors with specialized information about a range of victim behavior, to provide a proper context in which to evaluate the victim's behavior. You're not trying to match the victim's behavior with a typical or real victim, but you're really just trying to educate the jurors. You're not using the expert to give an opinion on this particular victim's reasons for a specific behavior, but you're really trying to lay a foundation for closing arguments based on factual evidence about how victims behave, and you're trying to counter defense arguments that the victim's behaviors support an inference that the victim is lying. A common argument by the defense is, we know how a real victim would act, and this victim didn't act that way. Therefore, you should conclude that they're not telling the truth and they're not a real victim. Calling an expert on victim behavior will really help to undercut a lot of those arguments and really present the jury with some truthful information about expert behavior. Excuse me, about victim behavior. When you introduce expert testimony, you want to identify what behavior you think the jury, what you think will cause the jury to disbelieve the victim. Is it the delayed report? Is it the subsequent contact with the offender? Is it the piecemeal disclosure? Is it the earnest resistance? Whatever it is, identify that behavior and decide whether to call an expert and whether the expert's testimony will be admissible. Is it available? And is it going to help your case? What are the pros and cons? You have to think about legal strategy in these cases and what's going to help hold the offender accountable and also explain the behavior. Again, sometimes you can do this with the victim, but in some cases you're going to want to call an expert in victim behavior. Every jurisdiction now allows this. Every jurisdiction has either a statute or a rule or case law that allows this to do. Talk to the victim, review the discovery, listen to the defense, listen to your colleagues and other professionals about the case. Talk to other witnesses and work with an expert to try and figure out the best way to deal with this so that the jury decides the case based on the evidence and the facts and not based on myths and misconceptions about victims' behaviors. This is a great case from the federal courts, actually it's from the military court system, but it says the behavioral characteristics or behavioral patterns of an alleged victim in a sexual abuse case may need to be explained by expert testimony, especially where that behavior would seem counterintuitive. Again, the law recognizes, as this case recognizes, that these behavioral patterns of victims of sexual trauma do not often make sense to jurors. People in their lives who do not work with victims of sexual assault, who are not exposed to perpetrators of sexual violence, may not understand how how victims act, how victims commonly act after sexual violence. And this is a great case that really gives a pretty thorough explanation of the need to call expert witnesses to explain victim behavior. If you can find an expert witness in victim behavior who actually has experience dealing with victims in confinement, that's all the better, because there are dynamics, there are other factors associated with victims who are in confinement that could be even more difficult to understand based on just the unique characteristics of incarceration. So if you have that, maybe someone at your rape crisis center who works with victims in confinement, that could be even more powerful in these cases. We'd like to talk about avoiding the danger zone, and what we mean by that is don't make sure that your expert doesn't give an opinion about the victim's credibility. You can't call an expert as a human lie detector. You can't ask your expert to testify about whether the assault did or did not happen. I talked earlier about not even having the expert examine the victim or give an opinion about the victim, but rather to have your expert witness just talk about common victim behaviors based on training, based on experience, and stay away from anything that can be seen as usurping the jury's province, which is to determine the credibility of the victim and the witnesses. It's an important part of prosecution to think always about how to combat the defenses. What the defense is going to be in this case? It can be it never happened, or someone else sexually assaulted the victim, but it wasn't me. You may have the case of consent if the inmate if the perpetrator is also an inmate, but that defense will not be available in our case because in the case that we were discussing, the perpetrator, the alleged perpetrator, is a staffer, and any type of sexual activity is criminal if it's a staffer with someone who is in confinement. You can't claim that it was consensual in our case, as I said. But sometimes you're going to have a situation where the defense may try and raise that claim even though the law says that consent is not a defense in these cases. If that's so, then litigate it. File a motion to preclude the defense from arguing consent if the law says that consent is not a defense. These two defenses, it never happened and it wasn't me, will include an attack on the credibility of the victim. Be prepared for a character attack, attacks on the victim's motives to fabricate, motives for her claim that the defendant did this to her, for the claim that it never happened. The defense may claim that the victim made it up entirely to either sue the prison or the state or the county to make money. Maybe that the victim they may say she's lying because she's angry about having been in prison. In terms of the second defense, it wasn't me. Are they going to say someone else did this to her? Then why would she try and pin it on this accused? What do we know about him? What's in the personnel files? What's, get an official contact and check with the official contact. What contact did they have on paper? Was it noted that he was her supervisor? Was it noted that he was supervising the laundry? Often the defendants will paint themselves as benevolent and well-liked. Fine, go ahead, and then I'll prove you weren't. Plus, you flip around that argument. If he was so well-liked as he would want you to believe, then why would the victim claim that he, rather than someone else, was the perpetrator of this crime? They're going to come up with things to try and escape liability, escape culpability for this, and you just have to anticipate it and deal with it. If you have a victim who makes a prompt complaint and you have DNA evidence, they may not be able to say it wasn't me if you had DNA. But when you don't have DNA, that can open up a hole big enough for the defense to drive a truck through. We have a question from a participant. Does victim behavior come into play when those per se illegal reactions between corrections officers and staff? Does victim behavior come into play with those per se illegal relations between corrections officers, staff, and inmates? If so, how? It does. Again, what we have here is a trial that's going to focus on an attack on the victim. They're going to attack the victim's credibility. They're going to attack the victim's likability. And anything that the victim does that does not comport with a lay understanding of how a quote-unquote real victim would act, the defense is going to use that to try and discredit the victim. The defense is going to try and introduce into evidence the victim's prior criminal history, the charges that the victim was incarcerated on, the underlying facts that support the charges the victim was incarcerated on, because they want the jury to dislike the victim. They're going to portray the accused as a public servant, almost like a law enforcement officer, a family man, clean cut in a suit. They're going to try and make him look like a fine, upstanding member of the community, and they're going to try and make the victim look like a criminal, an inmate, someone who they can't come out and say this, but they will suggest that the jury should not ruin the life of the accused based on allegations from someone with the history and character of the victim. These types of attacks happen all the time in these cases, and you need to expect them, you need to be prepared for them, and you need to constantly remind the jury and hold them to their oath that consent is not a defense, and that even if the victim consented, that does not mean it was not a crime. You have to basically hold them to their oath to follow the law, even if they may not agree with the law. And that can be difficult, but it can be done. Again, it starts with jury selection. It starts with identifying these biases, asking questions about it, and then continuing to educate the jury every step of the way, pointing out how dangerous it is for someone who is in a position of authority, like a corrections officer, who has so much power and control and coercive power over the people that they're watching in custody. Explain how dangerous that can be, and just hold them to following the law, even if the victim's behaviors are not what they would expect of a sexual assault victim. I mentioned this before, but the closing argument should remain offender-focused at all times. The defense will try and put the victim on trial, so it's so important for the prosecution to keep the focus on the offender. Everything they did, all aspects of premeditation, planning, victim selection, in some cases, just getting a job working in the prison may be part of the premeditation and planning that you want to talk about. Someone who got a job where they would be in a position of power over incarcerated individuals could be a big part of their premeditation and planning in these cases. Talk about credibility. It's so important not just to rehash what the victim said, but to explain why what the victim said is true. Statements that the victim made with the ring of truth, the level of detail that the victim gave about what happened, the victim's demeanor on the stand, the victim's demeanor when making the disclosure about what happened. Does the victim really have an interest in lying? Does the victim have some motive to lie? Talk about common sense. Talk about all the ways that what the victim is saying is corroborated. The prompt complaint, if you have the medical examination, the facts, the details, the request for a transfer after the assault. In some ways, delaying to make the report until the victim was out of custody could be explained as corroboration. They waited until it was safe. They waited until they were away from the perpetrator to make an official report. That could be part of their safety planning, and it could really make sense in a lot of ways for victims. We're coming to the conclusion of the webinar. These cases, just to summarize, these cases that involve sexual assault and confinement really do require focused and collaborative, investigative, and victim-centered resources. You have to focus on the offender's behavior and how he selected the victim, look for corroboration from a variety of sources, and carefully prepare to try the case in anticipation of the issues related to the recantation and non-participation. These cases can go forward with victims and without victims if you have good, strong, evidence-based investigations that can lead to evidence-based prosecutions. If anyone, we've taken a few questions during the webinar from participants. If anyone has any questions now, feel free to send them through in the chat, and we can do that now. Otherwise, we're going to shift over and talk about some of the resources that are available. We're going to send, you don't have to write these down, we're going to send you the handout with all of the slides from this webinar so that you'll have all of the resources available to you. The U.S. Department of Justice National PREA standards are available online. At AEquitas, we put out, one of my colleagues put out an article in our strategies newsletter, prosecuting cases of sexual abuse in confinement. We also have a prosecutor's resource on sexual assault in confinement, and there was also a film, Voices for Justice, Surviving Prison Rape, and we have the YouTube link for that film in our materials, which will be sent to you after this. If anyone has any questions, we'd be happy to take them now. Other than that, I don't think we have any. Charlie, can I hand it back to you?
Yes, we don't currently have any questions, but Chris and I will stay on the line for just a little bit longer, so if you do have those questions, send them over. I just want to thank you all so much for participating in today's webinar and for your attention during the time. If you do have questions about either trial strategies or the National PREA or the National Standards on Prison Rape Elimination Act, you can ask those at the National PREA Resource Center. And if you do have any questions at a later time, you can also reach Chris at his contact information here, and you can take email as well as phone calls if you have any questions. AEquitas is also a 24/7, as I mentioned before, service provider. We answer questions via email or phone on our website, www.equitasresource.org, as you can see on the card right here. And you can submit questions all the time, and we can help you prepare cases, answer any questions on trainings, and things that you're working on. And just thank you all so much for all the work that you do in the field. And like I said, we'll be on the line if you have any additional questions. And if not, just so you know, we will be sending out, as a reminder, we'll be sending out the PDF of this as well as Chris's biography, and there will be a recording of this presentation available on our website at the training page of our website later. Thank you.